All right, well, listen, I'm here with Evan Rosen from the law offices of Evan M. Rosen, and we're going to be talking all about real estate, transactional law, as well as foreclosure defense. So, Evan, you have the same last name. We're not related, but go ahead and introduce yourself. Tell us a little bit about your practice.
Sure. Evan Rosen. I'm a real estate attorney. I help people buy, sell, and refinance real estate, help people defend against foreclosure, and we also help people with estate planning and probate.
I'm confident, right? There's a lot of people that are pessimistic with insurance rates and things like that, or interest rates. But I am optimistic that the real estate market is going to continue to boom. It's going to come back. I know it was going crazy during the pandemic. It's kind of died off a little bit. It's going to come back. So how does a lawyer help someone sell their property?
Well, as a seller in Dade and Broward, you have a unique option. We have in the FAR bar form contracts, sellers basically have to prepare seller's docs, but you're looking for, as a seller in a transaction, a couple of things. You want to make sure you're getting every penny you're supposed to get, the prorations are correct, and so forth. You want to make sure title is properly transferred out of your name. God forbid someone slips and falls the day after closing and title wasn't transferred, you may have a problem. And you need to prepare the seller's docs by contract in South Florida. So that's the deed, an affidavit, and some other documents to clear title issues.
So there are some people out there, there's a lot of people that are the do-it-yourselves. They got the API, Chat GPT, they want to handle everything themselves. Why is it so important for a seller to get a lawyer involved if you're selling your property, if it's a house or an apartment where there's going to be significant money on the line?
Right. I mean, that's the biggest thing. So there's a lot of money involved, and you want to make sure things are done correctly. I was playing around with Chat GPT the other day just to see what it would do in terms of an estate plan, and it flat out told me I'm not a lawyer. So contact a lawyer. I was shocked by that response. Now, there are some things that Chat GPT can do at this point, but you need to get an attorney anytime there's a lot of money at stake, whether it's a PI case, a real estate, a matter, a transaction. But as a seller, you want to make sure you're getting every penny, and you want to make sure title is transferred. Those are the primary two things that I'm looking for to represent a seller in a transaction.
And so when you're representing the seller, as far as making sure that the title is going to be transferred properly, what are some of the things that you do, I guess, as an attorney to make sure that those things are effectuated properly?
Yeah, so there could be homestead issues where you're devising property, and you have to make sure that if the seller is a married spouse, that the other spouse who may not be on title is signing off to transfer homestead rights. Otherwise, you have a problem. By Florida Constitution, you can't transfer a property without that spouse's signature. So there's a number of things that come. There can be lien, there can be tax issues. So you want to make sure when you're selling, you're getting every penny you're entitled to, and that all title issues are resolved and cleared out at the time of closing.
And then, let's think about it from the buyer's perspective. And I have in the past purchased property, and when I was buying the property, the seller said, "You should use my lawyer too." And I knew as an attorney, I said, I don't think that's a good idea, because I want someone looking out for me. Why is it important for the buyer of a property, whether it's a house or an apartment, to have their own lawyer?
Yeah, so on the buying side, you want to make sure you're getting good title, that any liens are resolved, taxes, prorations, homeowners insurance, HOA or condo dues are taken care of. So you absolutely want to have your own person looking over that stuff. And in Dade and Broward, you get to select the title agent. And most often, even for a good real estate lawyer, it's going to cost about the same as it would for a title company. So you may as well get a lawyer for about the same price anyway, who's actually looking out for your interest, not just the interest of closing a deal.
So just, tell everyone who's watching, just, the average person who's watching this video, what is the idea of the fiduciary duty that a lawyer has to their client, either the buyer or the seller, whoever they're representing?
Right. Fiduciary duty comes up in estate planning, comes up in probate, comes up in real estate, comes up. It is a very high duty. Fiduciary duty is of the utmost duty that you can have to someone. You have to put their interest before your own. And if you can't do that, you shouldn't be a lawyer. It should be pretty easy for the most part for lawyers. I know it is for you, and thank God it is for me, to put my clients first. If you can't do it, you shouldn't be a lawyer, and you shouldn't be a fiduciary either. And so, yeah, that's an automatic out of the gate. You got to put your client's interest first. Can't do it, you shouldn't be a lawyer, period.
And, we've known each other for years, right? We've crossed paths. And obviously, because we have the same last name, people confuse me for you and Brad all the time. They're like, Evan. They come up to me like, Evan. But every single one of them that comes up to me, they're like, Evan is like, he's amazing. He's got a great reputation. You're out there. I know that you publish stuff, you write about stuff, and you're on the forefront of a number of foreclosure issues. And so why don't we talk a little bit also about this foreclosure defense, because it's a hot topic issue in Florida, because it happens often. It happens to ordinary people. What is foreclosure defense?
So foreclosure defense is a lot of things, but for me, it's a lot of things for a lot of people. And you often hear that foreclosure defense is about delaying and abusing the system, essentially, is what that means to me. You can't legally delay or ethically delay. You can't take steps for the purpose of delay. Foreclosure defense is not that for me. It's serving people. It's helping people in a bad spot. People come to me in foreclosure defense that they want to resolve a problem. They don't want to bury their head in the sand. They've done it long enough where now they know they need help, and if they don't get help quickly, there's the sheriff showing up at the door. So foreclosure defense is using what is in our toolbox ethically, zealously to serve a client. Look for issues similar to what a criminal defense attorney might do in a criminal case. Look for problems in the bank's case that I can use as leverage, or I may even prevail at trial. Thank God we've won the great majority of our trials. We've won appeals. But ultimately, I want to help people. Foreclosure defense for us is helping them out of a really bad spot. We've seen movies about the power of losing your home and the power that a home has for a family. And that has a profound impact on me. And it's called to me for a long time to help people save their homes.
And I know how passionate you are about defending people, right? And saving their homes, because listen, people fall on bad times. What are some examples of some of the things that can happen to a homeowner where it puts them in a position where they're either going to be facing a foreclosure or a default?
Yeah. So the most common issue is just life happens, things happen, and people get they lose a job, someone gets sick. One of the examples that comes to mind is I had a client, wife is a school teacher at Addicks Middle School, husband worked for DOJ, he was in Desert Storm, and their combined income was just not enough to live in South Florida. They were always one financial event or one family event away from foreclosure or from calamity, and that would happen. A kid would get sick, a kid would start college and have some unexpected expense, and so those things would happen, can happen to anyone, and it puts tremendous pressure, and those are some of the examples that we see. So
when in this timeline for people who are having some difficulty, they see in the horizon they're going to have a difficult time making a mortgage payment. When is it that they should reach out and start getting advice from a foreclosure defense attorney like you?
Sooner the better. I mean, there may be options that I can help them explore way before litigation comes to play, way before things get too out of control. There's some great lenders that I've worked with over the years who might be able to give someone a personal loan to get them current, and then figure something out to get the existing loan either paid off or refinanced. But the longer you wait, the harder it can become. Not always, but it can. You're going to have more attorney's fees, more late fees. It's much better to be proactive with these things and reach out sooner than later.
And the people that are facing the potential for foreclosure, what are some of the options that you're able to help them and advise them on to get them through the difficult time?
Sure. There's loan modifications, there's refinances, there's short-term deals. There can be a sale, and these times there's a lot of people have a lot of equity, so that gives options that we didn't have 10 years ago. And if need be, then there's litigation, and things can happen within litigation that create opportunities to work out a loan modification that might not have been there before. But you have to do something, because if you don't do something, and that's what makes my job a lot easier, is I'm able to communicate that to clients. Look, you got to do something. Because if you don't do something, we know what's going to happen. What guaranteed is going to happen if you don't do anything is bank's going to file suit. They're going to get judgment, and sheriff is showing up if you don't do anything. Now, if you take a proactive approach and try to resolve it, you open windows of opportunity either before litigation or during litigation that you hopefully resolve it.
And I think it's so important because there are so many different times, like if you think about the 2008 financial crisis, right? That was a time where a ton of people were facing foreclosures, but there were ways to help those people through it. And a lot of it wasn't their fault, right? It's these banks that are giving out these terrible loans, not looking into what's going on, They give a loan out. This family has their home. They think everything's going fine. And all of a sudden, things collapse and they're in default, right? I mean, what do you see, I guess, in historically from like that financial crisis? What did you learn then that you're able to apply today?
So there's so much that comes to mind from that. The movie Inside Job, narrated by Matt Damon, was just phenomenal. It starts off showing how Iceland put bankers in jail for all of the misdeeds and giving out loans to people they knew, and then that they couldn't afford it, and then selling it to investors as if these were, pots of gold, and they knew it was junk. And I'm toning the language down, but they knew these were sacks of shit, is what the phrasing was. So there was testimony of that on Congress. Things are different now, though. So that was then. Nowadays, people who are in foreclosure, it's not so much the run-up where banks were giving out money and securitizing and all those things that we saw. And, I railed against that stuff as much as anyone. Nowadays, things are different, though. Banking is the banking lending industry is generally, from what we've seen, much better at, scrutinizing loans, making sure people can afford things. I have a loan that's closing today where there was an issue and a person went into default on a credit card just a few weeks ago, and that threw the whole loan, had to reset because she had a default all of a sudden that she didn't have. And years ago, that would have been swept under the rug and there would have been no issue, but we're actually able to get it closed. The client was able to resolve the issue and the bank was satisfied. But I don't see that as much of a problem. But yeah, that was a huge motivating factor for me, is what the banks had done in the run-up to the Great Recession, if you will, the 2008 crisis.
And, lawyers like you that are handling and on the forefront of that, I look at it like the same kind of, with me, I was fortunate to be put into certain types of personal injury and wrongful death cases where I learned how to become a trial lawyer by fire. I was in the courtroom handling big cases, getting verdicts. Same thing. It's like you had the perfect training ground in 2008 to become the best type of foreclosure defense lawyer because you saw every single issue across the board. I mean, was that your experience back then and that you're able to use now?
It was phenomenal. So in 2008, at that point, I'm practicing law about since 1997. So I was about 19 years in at that point, right? And I had tried cases. I swam in your circle. I did PI with my father for a long time, and the foreclosure crisis came, and I had a lot of trial experience. And I had experiences in those cases, PI cases, that I was able to use in foreclosure defense that bank lawyers were not prepared for. And now it's very different. There's a lot of very experienced bank lawyers, but back then there were not. So it was a unique time. And then there were issues unfolding constantly. Securitization, this process of packaging mortgages together and selling them to investors on Wall Street, created all kinds of problems: evidentiary problems, standing problems, substantive problems, procedural problems, and we picked it apart. We had a blast. I won at one point in the beginning, and I'm still at about 70% win rate at trial, which is, to me, I'm still shocked by, because most of my clients have not paid as agreed. There are some who have paid as agreed, but the banks rejected payment, but that's rare. So still, I'm at about 70% win at trial, and for a while I was at 80 plus, and we weren't even getting to a final verdict. We were just excluding evidence because the bank lawyers were having a hard time getting in pay histories from other banks, getting in documents from other banks, and that created all kinds of fun. And I learned that from Judge Sigler in Miami-Dade on a PI case years ago, where the testifying orthopedic doctor, we tried to get in his physical therapist records, who shared space at his office, but the physical therapist didn't work for the doctor. And so a very good pro-insurance lawyer voir dired that doctor and said, "You didn't create these records. Isn't that right? You don't make these records. You don't keep these," on and on and on, and correctly got them excluded. So I watched and learned. That trial actually happened just as the foreclosure crisis would unfold, and we thought we would try to get in some evidence in the easy way. We ended up getting it in differently, but yeah. So that was a good.
So you've used the personal injury experience that you had before getting into foreclosure defense to use that in the trials that you've had in foreclosure.
Great mentors. Yeah, I've had tremendous mentors along the way, and those were all PI cases.
And what people don't understand is these foreclosure cases, do they sometimes become a complex trial where they need a lawyer like you to help get them through that process?
Yeah. It's not as often as it once was, but yes. So we have cases where during the pandemic, wonderful husband and wife and 2 kids that were sued, and they had they could have paid as agreed all along, and in fact were, but shortly after they got a loan, the bank went out of business, and they tried to contact the bank. They wrote letters, they called, they couldn't get through. It was IndyMac, they were gone. And so 11 years later, someone shows up in the middle of a pandemic claiming to have taken the paperwork from IndyMac and have the right to foreclose. And they're like, where have you guys been? And so that was a complex trial, put both clients in to testify, put on records from IndyMac, and we ultimately prevailed on a number of arguments. One of them was latches, was you guys waited too long for this. And foreclosures, thank God, are an equity, which creates an open door to talk about things that are fair. And it certainly was not fair to take someone's home who had the money all along. And by the way, on top of everything else, it was a variable rate HELOC, a variable rate home equity line of credit, so that the interest rate was variable and the principal was variable, because as you took money in and out from the HELOC. So the loan agreement, there was no fixed amount of money. There wasn't even an address or a date where to pay. The bank, by agreement, had to send statements saying the amount, the date, and the address. And they never did. They were out of business. So my clients were never in breach. They're in breach only after they get a statement that shows when, where, and how much, and then they don't pay. They never got statements. They get statements for 11 years. So on those issues, we prevailed. And then my clients ultimately paid it off at a super reduced rate.
So let's boil down some, like, just the example of the case that you just gave. You have a person that was put into foreclosure years ago, over almost a decade ago, wanted to pay and get out of foreclosure, was ready and willing and able to pay. The bank went out of business, and then 10 years later, someone showed up trying to take their home. And are these some of the things that you see in your practice, that like these things, all of a sudden someone's knocking on the door years later?
Yeah, it's rare, but yes, you do see some of that. The most common thing you see are people that have hard times and they fall behind, and it's, it takes a month or two or 6 or a year before the bank gets their paperwork together and files. There can be different things that slow things down. Like after Ian, banks slowed foreclosures for a bit. So, but yeah, the run-of-the-mill general case is what you'd expect. People just having a hard time making ends meet.
When those people are having the hard time making ends meet, why is it important for them to get in touch with you earlier as opposed to trying to deal with the bank and sending emails and correspondence back and forth?
So, the first example why it's important to contact a good lawyer out of the gate, and I think this is the same for your industry. If someone has a car accident and they contact a lawyer off of some, I don't want to disparage anyone, off of a park bench or just, the old days back of the Yellow Pages, who is a great marketer but maybe not a great lawyer. And there are people who are both. A present company here. But how does the insurance company respond to someone who doesn't have a great reputation? They may not offer good money. They may not settle at all. They may give them, they give them the runaround. Now all of a sudden, you show up or someone else with a really good reputation. Oh no, it's Eric. Damn, we're gonna get clobbered on this. We better, dot our I's, cross our T's, pay, or we're gonna hit with bad faith or whatever it is. Out of the gate by calling a good lawyer, and it's no different for foreclosure defense. I've thank God worked with every single bank firm down here, just about every single bank and servicer imaginable. I've tried cases, had appeals, Harvard lawyers, Ivy Leaguers, and so forth. I've gone against them and had great results, thank God, in most of our cases. So that helps create a leverage out of the gate. So contacting me out of the gate, one, is a good start just because of that, if nothing else. And then two, there are actual things that I may see or do. We have a very detailed questionnaire that we go through where we're like casting a net. I'm looking for potential issues. You may not even be aware that something happened in the processing of your loan that I know, what, not only am I aware of it, I've won cases on that issue before. So is that here? And so we have this very detailed thing where we ask and we dig to look for potential issues. And then most importantly, you contact a lawyer out of the gate, because the more time that goes on, the more attorney's fees, the more late fees, the more cost, the harder it gets. So the sooner you deal with it, the less likely it's going to be, more likely it's going to be favorable, and the more likely it's going to cost you less in the long run.
What, in your practice, tell me if you think it's the same as what I kind of see. So, you have criminal defense lawyers will tell people, keep your mouth shut. Like, you have the right to remain silent. The more you talk, you're probably going to talk yourself into problems. Same thing with personal injury lawyers. If someone's in an accident, right, we don't want them communicating or dealing with the other person's insurance company. We want them to allow us to get involved, to be their representation, and remain silent. You have a strategic advantage in doing that. Is it the same in foreclosure defense, where you have someone who's facing these issues to reach out and speak to the lawyer before the issues really become a big problem? So they're not speaking to the bank. They're not giving out information that would otherwise you would tell them, hey, Don't share that. Let me represent you.
It's not as much of an issue in foreclosure defense as it is in PI and criminal, because in the run-of-the-mill case, I'm admitting my client didn't pay as agreed. So if they say that over the phone, yeah, I'm sorry, I didn't pay, and you know, they're tugging on some other heartstrings. So there are times where I have a sophisticated client that I might say, you know what, before you signal that you have a lawyer, which may send a signal that you're hiding or you have money, or you know, maybe you ought to just try to call them first. That's rare though. Most often, the wiser approach is don't call them, don't write them. Let me handle that. Let me dot my I's and cross T's. God forbid you put something in the loan modification application that's different than what your bank records show, because they're going to ask for that too, or different than what your tax returns show, and then they claim that you lied on purpose. Well, now you got mortgage fraud.
So well, this is exactly what I'm saying. Is you should speak to the lawyer first.
Yeah.
Right.
Yeah. 9 times out of 10, it's the better call. Now there are exceptions, but yeah, I agreed.
Yeah. No, I mean, I just think that's the best approach.
Yeah.
So, how is it? Just explain, how is it that you get paid? How, like, what are your fees? Like, what's the contract like? I don't know the foreclosure world. We work on a contingency fee, meaning we don't get paid unless we recover money. But at the same time, we know someone has to pay a mortgage. They can't afford that mortgage. What is the option to get a great lawyer like you involved?
So we have a contingency fee, T, but it's totally different. I'm ethically prohibited from taking an interest in someone's home. I don't want to do that. I don't want to be the bank. I want to help them. I don't want to be another lender, another mortgagee is what the term would be. We do either payment plans or an hourly rate with a retainer. The contingency is that if we're successful and the bank has to pay, then we'll seek our full hourly rate from the bank. I don't want it to come from the client. So we keep a reasonable fee for our clients, and every now and again we hit a home run and win a case or have a good trial or a good appeal, and then the bank is obligated by court order to pay fees. Then the agreement allows us to seek a higher rate based upon a fair rate that we've been approved by multiple judges, but I don't charge my clients that. I charge my clients a lesser rate.
Okay, so generally, with when you're representing someone, they're going to be paying you, like a payment plan over the next months while the case is pending.
That's one way to do it. That's historically how we've done it, and I don't want to give a quote over.
Sure, yeah, no, obviously you're not going to give a quote, but
right.
At the end of the case, are you able to try to recover that money back for them?
Right. So there's two different ways. One is a monthly payment plan. The other is a more traditional reduced hourly rate. And if we're successful in getting our attorney's fees, there's been many cases where we're able to reimburse our clients. So not only do you keep your house, get a principal reduction, whatever it might be, then you might as well also get your attorney's fees reimbursed.
That's really great.
Those are great days. I love giving checks to clients.
Yeah. I mean, listen, not only to keep their home, but they also get their check back, so they don't have to pay. They didn't have to pay the entire time. I mean, they had to pay while it was going on. But listen, I think it's an incredibly noble way to help people. I'm all about the lawyers that are there to help the consumers, help protect consumers, help the ordinary people that have ordinary things that happen in their lives, difficulties. And if they're not able to make a payment, the bank starts hounding them, to be able to have a good lawyer to come in and defend them.
All right. We're not trying to, most of my clients don't want something for nothing. They're not trying to beat the bank on, and get away with not paying what's agreed. Most of my clients will tell me, I want to pay. I know I owe money. I want to pay as agreed, but they need help getting through it. So if the egregious example, if a child molester is entitled to counsel to make sure the state doesn't bend the rules, we don't ever want the government convicting someone wrongfully of some horrible crime that they didn't commit. So we have this type 1 and type 2 error where we want to make sure people are represented. You should have a lawyer too for not paying as agreed. It's not a capital crime. Get a good lawyer. Make sure your I's are dotted. You're protected. The bank has to dot their I's and cross their T's. I've made this closing argument pitch multiple times. It should be no different for the bank than it would be for anyone else seeking to take someone else's home. They should have to prove their case. And most cases, the bank that's foreclosing is a bank that's not on the loan documents, never made a phone call to my client, never sent them a letter. It's some XYZ bank or someone they've never heard of. And so, again, before they take someone's house, they should just be required to prove their case like anyone else.
All right. Well, listen, it has been a blast having you here. I'm thrilled that you came by. Evan Rosen, not my brother, but brother.
Amen. Thanks, Eric.
I appreciate it. I think this is going to be a fantastic, useful tool for a bunch of people who have questions about foreclosure defense, real estate. So how can people get in touch with you?
Sure. I'm an 855 number, 855-55-ROSEN. It's an easy number to remember. info@evanmrosen.com, info@evanmrosen.com. Google me, pretty easy to find me.
And the website, what's the website?
Website, of course, evanmrosen.com. EVAN.
Instagram account?
Instagram account is probably Evan M. Rosen as well, but yes.
All right, everyone should look for Evan Rosen when it comes to real estate transactional law, real estate litigation, as well as foreclosure defense.
Thank you. Estate planning, probate as well. And you know, I appreciate you doing this and bringing people out. This goes to show your servant's heart. There's a great PI mentor that I had many years ago talking about a servant's heart. You probably know who he is, but I'll save the name for later. He was a phenomenal president of the Florida Trial Lawyers at one point. He's a Marine helicopter pilot. I'm probably giving it away who he is. Maybe not. So, but he talked about a servant's heart, and you have it, Eric. And you're not just trying to help people with personal injury cases, med mal cases, tobacco cases, and so forth. You're looking to help other lawyers. Genuinely.
That's it, man.
I see you, and you put a lot of time and energy into this. So I'm grateful. It's great to commit to do this with you, to work with you on this stuff, and you've done a great job in the PI space. Thank you.
All right, my friend. Thanks for coming.